Good morning, I'm Gary DeWaal, and this is Bridging the Week for May 15th to 19th, and today is May 22nd, 2017. The likely unintended consequence of seemingly innocuous amendments to a CME group rule could impose almost impossible burdens and increase potential liability on clearing members for direct access clients they authorize. Moreover, while many firms struck by the malware WannaCry 2 weeks ago continue to struggle with recovering corrupted data, the U.S. Department of Homeland Security, the Securities and Exchange Commission, and the UK Financial Conduct Authority issued useful guidance to help minimize the potential destructive impact of future ransomware attacks. This is the last edition of Bridging the Week prior to the Memorial Day holiday, so I can get away for a few days holiday as soon as possible. Let's get started. CME Group announced amendments to its rule related to Globex order entry that will affirmatively require all persons that enter orders electronically into Globex to ensure that all mandatory order trail fields are input accurately in the first instance. Currently, such obligation applies to only a few specifically enumerated fields. However, as currently is the case, clearing members that authorize such persons access to Globex would be, quote, responsible for the Globex terminal operator's compliance with this rule, end of quote, even when such operator is a third-party client. This potentially would make clearing members responsible for all their non-affiliated direct access clients' accurate input of all CME Group required order trail field information. Unfortunately, these seemingly innocuous amendments by a CME Group rule could impose a Damoclean sword of almost impossible burdens and increased potential liability over clearing members for direct access clients they authorize. This does not appear to be the intent of the CME Group, but it does appear to be the consequence. Hopefully, CME Group will rectify this issue through a further amendment to the rule or issuance of a clarification in a market regulation advisory notice or otherwise. CME Group's revised rule is scheduled to be effective May 31st. In response to the May 12th global ransomware attack, principally known as WannaCry, the U.S. Department of Homeland Security, the Securities and Exchange Commission, and the UK Financial Conduct Authority issued guidance advising persons how to prevent, detect, and potentially remediate the specific malware, as well as how to defend against ransomware generally. In particular, to guard against future attacks, Homeland Security encouraged all persons to follow specific precautionary measures. Make sure antivirus software is the current version. Ensure copies of sensitive or proprietary data are routinely prepared and stored on a separate and secure location. Backup copies of sensitive information should not be readily accessible from local networks. Review with caution links contained in emails, and do not open attachments included in emails that are unsolicited or unrecognized. Download software, especially free software, only from known and trusted sites, and enable automated patches for operating systems and web browsers. The SEC and the FCA all had their own insights on their recent WannaCry attack, as did some of my colleagues at Katten last fall. Check out all these insights on the article version of Bridging the Week on the website. And finally, hedge fund icon Leon Cooperman and his firm, Omega Advisors, a registered investment advisor, agreed to resolve charges by the Securities and Exchange Commission without admitting or denying any allegations that they engaged in insider trading by paying $5 million and agreeing to the imposition of other sanctions. Last September, the SEC charged that, in 2010, Mr. Cooperman obtained non-public information regarding divestiture plans of Atlas Pipeline Partners, a company which he owned and controlled a substantial number of shares. Despite providing assurances to the APL executive who provided him the non-public information that he could not and would not trade based on it, he in fact so traded, claimed the SEC, and Omega advises and he profited. The SEC also charged that, over 40 times, Mr. Cooperman failed to timely report to it, as required, information about the securities of publicly traded companies that he beneficially owned. Among the other sanctions agreed to by the defendants were that they must retain an outside independent compliance consultant through 2022 to access electronic communications and review trading, make monthly certifications that they did not trade in inside information, and outsource their required beneficial ownership filings. The CFTC has also recently charged and settled with 2 defendants insider trading type actions relying on a theory of misappropriation. Check out details of these actions on the article version of Bridging the Week on the website. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great 2 weeks, and until the next edition of Bridging the Week on June 5th, ciao.